The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. I'm Ginny Van Duzen, Director of Alumni Career Development at Holy Cross, and I'd like to welcome you to today's webinar. This is the next installment in our series of web-based presentations covering a broad range of career development topics. Today, I'm happy to welcome Ricardo Granderson, Principal and Founder of the Granderson Group, an employment dispute resolution consulting firm. Ricardo's experience includes employment law, diversity, dispute resolution, human resources, claims, and training in both the public and private sectors. We'll be together for a little under an hour. Ricardo will speak and will then take questions from you for as long as time allows. I encourage you to submit questions throughout this presentation by checking out the question function located on your webinar toolbar to the right. Thanks again for joining us, and now it's my pleasure to turn things over to Ricardo.
Good afternoon. My name is Ricardo Granderson, and I am the principal of the Granderson Group. The Granderson Group provides strategies to companies in the area of employment practice liability. In short, we help companies predict, prevent, and resolve employee complaints and lawsuits by way of dispute resolution. That is, we use tools that include mediation, audits, consultations, and live seminar training. Incidental to these services, we also provide information to colleges, universities, alumni associations, and professional groups about strategies for effectively negotiating the contemporary workplace. Which leads me to today's topic, strategies for unexpected career changes and returning to the workforce after planned leaves. I graduated from Wesleyan University, City University of New York Law School, did training in mediation at Columbia University Law School, and also trained at the Cornell School of Labor Relations. I have 16 years of experience that includes serving as Employment Practice Liability Claims Counsel in financial services, Equal Employment Opportunity Officer in the public sector, and Director of Legal Recruitment and Diversity at a not-for-profit. I've been on the Labor and Employment Committee and the Diversity Committee at the New York City Bar Association and have mediated cases for the EEOC. When I graduated from college 32 years ago, I interviewed at what was one of the Big 8 accounting firms, Arthur Andersen, and also an investment bank, Lehman Brothers. These were firms that had existed for more than 100 years, and now they're gone. A workplace where one graduates and works for 1 to 4 employers for 30 years, consequently or subsequently receives a gold watch, then retires, that workplace no longer exists. Mergers, acquisitions, outsourcing, and changes in technology have created a more tenuous and volatile workplace, but one where opportunities are only limited if employees do not understand how to strategically negotiate the new landscape. This webinar will provide insight into effective strategies for success at any career stage. Specifically, the webinar will help you to better understand the following. 1. How to recognize the indicia of change in your workplace such that it should prompt contemplating a transition. 2. How to protect your reputation and increase the likelihood that you will survive an involuntary transition or layoff. 3. You'll learn some of the negotiation strategies when presented with a severance offer. And 4, a blueprint for re-entering the workplace after a planned leave. The presentation will cover a range of topics. You should note that there will be a few brief fact patterns which are used to illustrate certain issues. I received a few questions last week and have set aside some time at the end for responses to those questions and to any new questions that you may have during the presentation. Before we begin, I'd like to engage in a brief exercise that we will revisit at the end of the presentation. Your role, obviously, is to listen to the fact pattern and then to think about whether you would either A, hire, or B, not hire the candidate described in the scenario. At the end of the webinar, I'd like you to email me with either your A, higher, or B, not higher response for a short poll with regard to your responses. Here's the scenario. You are now the CEO or the Chief Operating Officer of an organization, and your job is to hire a senior level, similar C-suite kind of executive. You get a referral for a candidate who has 20 years of relevant experience. This person is a double Ivy League graduate who graduated at the top of the class at both academic experiences, so both undergraduate as well as graduate school. The person, in addition to years of relevant experience, they have a track record of adding value, a track record as being a recognized leader in the industry. In addition to that, has references and a sterling reputation. However, during the course of the interview, as you're interviewing the applicant, for one reason or another, you do not like the tone and timbre of the person's voice. You don't like the way the person's clothing fits, and for one reason or another, you just do not like this candidate, despite the fact that this person is objectively the best candidate. The question is, would you hire this person or would you not hire this person? We'll revisit this at the end. Let's start with the workplace basics. LinkedIn profile. LinkedIn is something that evolved, I guess at this point, maybe 20 years ago, and most employees, most professionals are engaged at various levels. Unfortunately, while most employers do not have any sort of practice or policy with respect to HR that says that LinkedIn is a condition or a precursor to employment, the practical reality is that 95% of those who will be interviewing for jobs expect to see a LinkedIn profile. In fact, they regularly check the LinkedIn profile in order to get a sense as to who the potential applicant or candidate is. And the way that it will work is, if Jane Smith is applying for a job, she will notice at some point she'll get a response from LinkedIn that says someone or people are viewing your LinkedIn profile. Therefore, a LinkedIn profile is presumed. You should learn the narrative of the employer. In the for-profit world, when you're interviewing, you need to make sure that you find a way to expressly and impliedly convey that you have a track record or that your skill sets are such that you add value. If you're interviewing for a government position, then the narrative there is one of that your skill set is such that it will add to the necessary and important governmental services. In the not-for-profit space, the narrative or the language is such that your skill sets must go to the mission of the organization. You should prepare for panel interviews and structured interviewing. Panel interview obviously is a listing or an assemblage of anywhere from 3 to as many as 7 people, and structured interviewing is the idea that the same questions will be applied to all applicants. Soft skills get you the job. Technical skills help you keep the job. I'll say that once again. Soft skills get you the job. Technical skills help you keep the job. What are soft skills? Soft skills are the kinds of skills whereby you are making some connection to the employer. If I were a Holy Cross alum, then I would make sure that if I'm interviewing with a Holy Cross applicant, or rather interviewer, that I've made it my business to disclose and try to cultivate connections. So with regard to fraternities and sororities that we may have in common, whether we play sports. Something else that should be pondered and reflected is when interviewing and you're presented with interview options, you want to elicit, if possible, the names of all of those on the interviewing panel so that you can prepare appropriately. It's important for you to prepare, and many employers presume that applicants will do some research with regard to those on the interview panel. Job posting less than 30 days. If you see a job posting and its duration is less than 30 days, then it's a red flag and indicator that there is a presumed and presumptive incumbent or designated hiree. Know your value as it relates to the market rate and why. That's important with respect to salary negotiations and offer. You never want to accept a job out of desperation. You should never accept a job at less than market rate, because that will lead to the practice of always trying to chase and secure greater compensation. Consequently, it's imperative that you're always aware of your market rate and value and why. If the market rate, for the sake of discussion, for a first-year associate or third-year associate, either at an investment banking firm or a law firm, is $150,000, or for the sake of discussion, let's say it's a lower-level position at $50,000. However, you have the kinds of experiences whereby you've added value, then clearly your market rate would be higher than the existing rate. 360-degree management of expectations. What that means is that you need to be able to manage the expectations of both of your superiors, your peers, and your subordinates. The idea is that by managing expectations, by being able to perform as promised, that you will create an impression of you being a value-added employee. Play nice with others and lead when asked to lead. Play nice with others is obvious, that in the workplace, what's paramount is that you be a team player, that you be collegial. And when given an opportunity and asked to lead, it's important that you lead, because that's an opportunity for you to grow and thrive in the organization. Respectfully ask for raises based on performance. Based on my 16 years of experience as a professional and as an adjunct professor, I've conducted polls and surveys to suggest that as much as 85% of those in the workplace have never asked for a raise. That most people essentially defer to the industry. So if you're in financial services or if you're in sales, there are these presumptions that raises and bonuses are part of the landscape. However, the reality is that employees, especially if they are valued employees, should ask for raises, and management, more often than not, expects valued employees to respectfully ask for raises based on performance. Change in management usually leads to organic changes. In other words, new management team is hired, you should be prepared that there would be changes in the organization as it relates to staffing and personnel and policies and practices. Caveat, performance improvement plan. A performance improvement plan ostensibly sounds benign and well-intentioned. However, whenever you see or you hear of the specter of a performance improvement plan being raised in the workplace, its purpose is to terminate an employee. It is the pretext before an employee is terminated. Do not accept the first offer in a severance package. If I just show up on time and do my job to the best of my ability, work hard and support the team, I'll be able to have a lengthy career at a company. This was a presumption, and probably true, about 20 to 25 years ago and beyond. The reality of the modern workplace is such that mergers and acquisitions are now a modern part of the contemporary landscape. When Company A merges with Company B, they will not keep two marketing divisions, they will not keep two legal divisions, and obviously changes have to be made with regard to staffing. Reorganizations and downsizing are also part of the new landscape, and the issue of lack of cultural fit and employee at will. There are preferred relationships with employers, and I thought it was important to list them here. The best and most important and most significant relationship that you can have with your employer is a contractual one. If you have a contract in place, it means that you can participate in crafting the terms and conditions and duration of your employment. It's an extremely powerful position. The next level of power or security, if you will, is really with respect to lower-level employees, entry-level and mid-level employees, and that's a function of a collective bargaining agreement, which is a contract that is usually negotiated by a union with management. The employment at will doctrine is the least powerful position, albeit standard and prevalent. Fact pattern number one. Mary Smith graduated from Holy Cross College with a degree in economics and then from the University of Chicago with an MBA. She has been the Chief Economics Officer for a Wall Street firm for 17 years, where she reported directly to the COO, or Chief Operating Officer. Banyai Best, who graduated from Boston College, was hired as the new COO at Mary's firm. Banyai, who had a reputation of having a huge ego, met with all senior staff except Mary because he was, quote-unquote, too busy. Mary's first evaluation from Banyai was all negative, and she was placed on a performance improvement plan. Before this recent evaluation, Mary had been considered an asset by peers, C-suite, and subordinates. Should Mary be concerned? Mary should not be concerned because she went to Holy Cross College. Choice B. Mary should not be concerned because she went to Holy Cross College and she has an MBA from the University of Chicago. Choice C. Mary should not be concerned because she went to Holy Cross College and has an MBA from the University of Chicago and has a reputation at the firm as having a track record of adding value. Mary should be concerned. Signs of workplace change that should signal time for transition. I've listed them there for your review, but I want to focus on the performance improvement plan. When you see a performance improvement plan, or when a management team or staff decides to use a performance improvement plan, invariably you will see a specific duration of days by which performance must be demonstrated. It's usually anywhere from 30 to 60 days, and the language usually reads something to the effect of, if performance is not improved, then consequences will result up to and including termination. As I said earlier, the performance improvement plan is a red flag, and anytime an employee or a manager sees or must participate in a performance improvement plan, more often than not, it is a pretext to termination. Change in management is a sign that there will be changes with respect to staffing, policy practices, and procedures. Reorganization, poor financial health of an organization, a company or a not-for-profit, is usually an indicator that there will be changes. Terminations, severance packages, and outsourcing. A note about severance packages, that there are no guarantees that companies must or should offer severance packages. I'll say that once again. There are no guarantees that companies must or should offer severance packages. What happens is that companies decide that in the interest of good faith and an attempt to mitigate the possibility or probability of lawsuits or complaints, they offer severance packages with those intentions. Outsourcing. As part of the, usually associated with the severance packages, but sometimes as a singular service, outsourcing is an indication that there are going to be changes, and employees should always avail themselves of any outsourcing opportunities. Protecting yourself and your reputation in the workplace and increasing the likelihood of surviving the transition. When there's a new management team hired into any organization, it's extremely important to expressly convey to the new management that you want to be part of the team. And this is usually and best done if it can be done face-to-face. That if you can make an organic and intrinsic human connection with the new supervisor, the new director, the new CEO, anyone in the position of authority, then it increases the likelihood that they will feel and recognize a need to have you be on the team. Moreover, it's important that not only that you make that connection, but you talk about the extent and the duration of your tenure, as well as the achievements of your tenure. If you've developed marketing strategies that were effective and inured significant financial benefit to the firm, that should be mentioned. If you developed policies and procedures that mitigated risk, that should be mentioned. If you implemented systems and procedures that resulted in the organization being recognized as, for example, a best-in-class firm or employer, that should be mentioned. So in addition to expressly conveying a need, or rather an interest to the new management team that you want to be part of the team, it behooves you and behooves an employee to convey his or her achievements as well. It's also important to elicit the new expectations from the new management team if available. I say if available because sometimes when new management is transitioned into the workplace, they may not, by the time they meet with you or meet with staff initially, they may not have an accurate and thorough understanding of the operations of the organization, of any existing strategic plans, so their interests and goals may not be available at the time. If they are available, then what you want to do is elicit and identify those expectations and effectively manage those expectations, just as an illustration of managing expectations. I'm going to presume that all of us have traveled by airline at one time or another, and for the sake of discussion, let's say we were getting on a flight starting from New York City heading out to Los Angeles. Usually there'd be an announcement that would say something like we'd be flying at an altitude of 15,000 feet at a certain altitude, but in addition to that, the expectation and the duration of the flight will be 6.5 hours. What subsequently happens is either at the 5-hour and 50-minute mark or at the 6-hour mark, you'll hear something like, we have begun our descent into Los Angeles, which means that the arrival time was actually a half an hour earlier. That's an illustration of managing expectations. It's when you have identified specific goals for your management and you will exceed those management expectations. So if you have a project and you're aware that under normal circumstances it will take 3 weeks to conduct and facilitate that project, then it would behoove you to find a way to hasten and produce that project in a shorter period of time. You want to seek out assignments with visibility. That's important because the most successful employees at any firm usually have had opportunities to be visible. That is, giving presentations, working on high-level projects, working on the kinds of projects that go to risk or to bringing in resources and value to the organization. Maintaining a diary. Maintaining a diary is extremely important with regard to one's professional strategic plan. Maintaining a diary will allow you to chronicle and memorialize your achievements, which are important when you are asking for or making inquiries about raises or promotions, which are important when you are making inquiries or asking about promotions and specific business opportunities in the workplace. It's also important in the event that you are ever presented with a performance improvement plan, because a diary will allow you to say, for example, that between the years of 2014 and 2016 that you have exceeded all of the financial thresholds by more than 45%. In the worst case scenario, in the event that there is an involuntary separation, layoff, or termination, maintaining a diary is also an effective tool for your lawyer if those situations arise. Fact pattern number 2. Mary Smith was presented a severance package of 6 weeks. Mary's salary was $125,000 per year. Thus, the package offered 6 weeks of salary in a single lump sum payment. What do most employees do in Mary's situation? A, accept the offer. B, get a lawyer. C, try to negotiate pro se on their own. Or D, get a lawyer to negotiate. Well, what most employees do is accept the offer, which is a bad strategy. And it's a bad strategy because anytime you accept a first offer in a severance process, that you have decided to forego your ability to participate in a negotiation. And what happens is that employers strategically present the severance offer without any sort of prior notification to the employee, so that when the employee receives the severance offer from their HR director, usually in the HR office, having been told that their services were no longer needed, there's a degree of stress and anxiety involved. Therefore, the employee usually is not in a position to effectively even contemplate negotiation. What's important, however, is that within the severance offer, as standard operating procedure and course, is that the employer usually gives you about 21 days ultimately to decide whether you will be accepting this particular offer. So therefore, it is incumbent upon the employee to accept the severance letter or package, take a few days just to decompress, to relax, and so that way the employee is thinking in the most lucid and ordered way. And then think a negotiation, because that's what's going on, that it is incumbent upon the employee to be cognizant of the fact that when he or she is presented with a severance package, that a negotiation will be ensuing. Therefore, it should not be a part of your practice to accept an initial offer. Just a few comments about getting a lawyer. That in the event that the layoff or the reorganization is a function of a benign business decision, that is, as the corporation looks at the fiscal health of the organization or the firm or the entity, that someone is making a financial decision and not a personal decision with regard to you, then it's probably best, at least at first blush, to attempt to negotiate a package on your own. Why is that? Because when you secure the services of counsel or retain counsel to negotiate a severance package, there's a cost. And that cost can range anywhere from as low as $2,500 to as high as $5,000, depending on the nature of the relationship and what's involved. So it's costly. There's a cost. The other thing is you find that corporations, especially, well, corporations invariably will be represented by counsel, and usually the initial negotiation is offered and tendered by someone from HR. But what happens is, as the employee attempts to negotiate, depending on what's going on, they may find themselves negotiating with an attorney, and sometimes employees feel psychologically intimidated if they're not attorneys themselves, and quite frankly, even if one is an attorney, it's best to have someone else negotiating on your behalf so that there's a degree of objectivity. What should Mary do in this situation? Mary should attempt to negotiate. As I said before, the nature of the employer-employee relationship should determine whether Mary retains counsel. If the separation is a result of a benign occurrence, then Mary should attempt to negotiate pro se, at least initially. And if the relationship devolves and becomes adversarial, Mary should retain counsel. I want to digress for a second and say something about a lump sum payment versus salary continuation. In the event that you are negotiating a severance package, it would be in your best interest to always, and I very rarely use the word always, but I will use it in this context, to always request a salary continuation, because the lump sum payment offer is really in the best interest of the employer with respect to taxes, whereas the lump sum payment offer is really to the detriment of the employee. For example, if the employee is making $50,000 and $50,000 per year, and the severance package is such that the employer is willing to offer 1 year of salary, which would be somewhat unusual because the parameters for severance, at least in practice, is anywhere from 1 to 2 weeks for each year. So for the sake of discussion, if someone gets an offer of 1 year and it's $50,000 or $60,000 and it's a lump sum payment, then that singular payment will be taxed at a certain level. It will be taxed at such a level that the actual financial benefit or payment will probably translate to more like $35,000, if not less than that. That is why salary continuation should be the default and preferred request, because salary continuation will allow the employee to continue to receive payments in accordance with the current salary payment schedule of the employer. You should note, as I said earlier, that severance packages are not guaranteed. If you're going to negotiate, then negotiate. Identify your leverage. For those of us who have been in business at any time and those who are just starting out, you understand that ultimately negotiations are about leverage. Do you have information? Do you have evidence? Do you have communication? Do you have insight such that it would translate to leverage, and that leverage can be used to buttress the terms and conditions of your offer? Leverage can be past significant performance, but leverage, unfortunately, can also be examples of bad behavior by principals or coworker. You want to identify reasonable terms. Now, what's reasonable? A reasonable term would be outplacement. A reasonable term would be, depending on the nature of your separation, would be that the employee gets an opportunity to draft the reference letter. And not only the reference letter, but the communication that will be used for subsequent employers who are inquiring about your performance. It's important to note that as a general rule, most employers limit their communications with respect to separated employees to the title of the job, so that John Smith worked as the Chief Marketing Officer for 3 years from January 1st, 2012 to December 31st, 2015. And in some instances, they make representations with regard to salary. But generally speaking, corporations are usually reluctant and averse to making anything that translates to an endorsement of an employee for a variety of reasons. Fact pattern number 3. Mary, after 5 rounds of interviews, left the Rotex Corporation, where she was employed for 5 years, and took a new job at Phone Bank LLC as an employee at will, at a salary of $100K. After her second week, Phone Bank's CEO decided to eliminate her position. Phone Bank offers a 1-month severance, or 4 weeks. So think about that. She had a job where she'd been working there for 5 years. She interviewed after a series of interviews and started a new job with all of the hope and excitement that we all feel at a new job. And after 2 weeks, was informed that her position was eliminated and that she was offered a 4 weeks severance package. What are the issues? Issue number 1. Well, before broaching the issues, I think it's important for all of us to understand that whenever there is a workplace action or adverse action in the workplace, there are the ostensible facts, in other words, what we see, what we hear, and then there's what actually happened. In this instance, even though the CEO has declared that the position will be eliminated, and in fact the position ultimately was eliminated, what really happened was that either the CEO, after spending 2 weeks with Mary, did not like Mary for one reason or another, or someone else in management, after having opportunities to interact with Mary, did not like her. That's what happened. In fact, that's what happened in this particular fact pattern. In any event, the issues are as follows. Number 1, that Mary relied on the representations of the employer to her detriment, which is a potential legal issue that would provide some leverage if used. Mary is now unemployed and does not qualify for unemployment. At this point, I'm in New York City, so I'll use the state of New York as a reference, because it varies in each jurisdiction. In the state of New York, in order for an employee to be able to avail himself or herself of unemployment benefits, they must have worked for at least 2 quarters, according to the Department of Labor, or 6 months. So in other words, in order for your rights to vest as it relates to unemployment benefits, you must have worked for at least 6 months and have not been terminated for cause. Cause would mean some sort of impropriety, performance, inappropriate behavior. That's for cause. So Mary finds herself in a situation where she is unemployed and cannot qualify for unemployment because she's only worked for 2 weeks. Third issue, Mary has no health insurance. Issue number 4, Mary's reputation will be adversely affected. Issue number 5, which, albeit not technical or legal, will govern and affect everything that occurs subsequently. Mary is angry and hurt. Usually when someone files a lawsuit or goes to a federal agency to complain about any sort of issues in the workplace, what is motivating that filing is that the employee is angry and hurt. What request may resolve Mary's issues? Okay. What's important to note is that the employer made an initial offer of 1 month or 4 weeks. So if Mary is thinking, Mary understands that she's now in a negotiation, and it's important to make a counter offer. I think it's important at this time for me to stop and convey that with many employees there is a fear that if they do not accept that initial offer and they make a counter offer, that the employer will take away or revoke the initial offer. The likelihood of that happening is slim to none, because when an employer makes a severance offer, it's an indication that they want to offer some degree of compensation for what has occurred. It's not an admission. It's simply that the employer is recognizing that they want to provide some sort of redress to address what has occurred. So in any event, in this case, Mary should make a counter offer, and liberally speaking, while she has only been there 2 weeks, that a counteroffer or something comparable or reasonable would be that she would be requesting 1 year's salary, 1 year of benefits, unless Mary gets a new job. The separation should be deemed as a layoff as opposed to a resignation, because a resignation would disqualify Mary from being able to collect unemployment. Mary should also ask to draft the letter that will be used as the basis for referrals by any subsequent employer. Something else that's considered reasonable is that having the employer agree not to challenge any unemployment request if made. Outplacement is also reasonable. It's also reasonable, I've seen employees to make requests for the employer to pay for additional training. So if someone is in financial services and they have an interest in public health, I've seen employers pay for training, even degrees and courses in other areas of expertise. Okay, we've just explored the situation with Mary in a hypothetical way, but this was an actual situation, and I wanted you to get a sense as to what the final package actually looked like. So Mary requested 1 year. What was ultimately offered was 5 months of salary. So she received about $42,000 plus 3 months of COBRA, because she had no unemployment, had no insurance or benefits, paid for by the company, a letter drafted by Mary to be used as a reference by the firm, and also she got outplacement, as well as with regard to the salary payment. I mentioned earlier that there are generally 2 options. There's the lump sum, which is usually better for the employer, and there's salary continuation, which is better for the employee, and both impact on taxes or have tax implications. In this case, what was presented was a hybrid approach. It was 2 months lump sum payment followed by 3 months salary continuation. You should note that the negotiation lasted 5 months, where Mary was without income for that period of time. Surviving a separation. Point number 1, you should not take it personally. I'll say that again, that Sometimes a separation or termination is based on some personal motivation or even animus, but in order to proceed and to be successful in a subsequent job or opportunity, it's important to not take it personally. Think of it as a business decision, as your severance negotiations should be based on business decisions and not emotions. Take some time off. You should avail yourself of outplacement services. Let your colleagues and friends know that there's been a separation, and don't be negative. That there is something about the human condition such that human beings are more likely to help another human being if that person doesn't need help and if that person isn't complaining. So if you say to your friends, I was fired by such and such a firm, or they laid me off and those people were not nice to me, they made ad hominem attacks, they manufactured issues that didn't exist, that usually doesn't bode well with regard to the kind of network that will help you get your new opportunities. Develop new skills. Look at continuing education and reinventing yourself. In this modern workplace where turnover is now the norm, 25, 30 years ago, if you were only at an organization for 2 months, 3 years, 16 months, those would have been red flags. In the modern workplace, there is an expectation that people will be moving, and as professionals, I've seen judges who were judges all of a sudden end up working as administrators at colleges and universities and high schools. I've seen educators transition into the development space in fundraising. So it's important to really look at your skill set and think about what subsequent industry or industries will value your skill sets. Returning to work after a planned leave. Once again, continuing education is extremely important, especially if you've been out on some sort of a leave, because it's incumbent upon you to keep abreast of any changes in the doctrinal area or substantive area in order to maintain your competitive edge. You want to identify any strategic relationships. I've highlighted headhunters as one example. You should note that firms and businesses only use headhunters about 3% of the time in searches, and they're usually for higher level roles and positions. It's important to note that as many as 85% of jobs are not published at the time that the hiring management team actually is contemplating the job. So the way that things usually work is they work based on relationships. So if I'm friends with John Smith and John Smith has all of the requisite qualifications, invariably what the employer will do is draft a job description that reflects John Smith's resume and skill set, and then, because the law requires, will post the job and receive, for the sake of discussion, I don't know, 50 resumes of ostensibly qualified applicants, and will ultimately interview about 8 of those people, and all of those people could probably do the job, but John Smith as the internal candidate will ultimately get the job. So therefore, strategic relationships are important. When you're applying for a job anywhere, it's important to ask this question, who do I know? And I'm going to use the not-for-profit space as an illustration. If you're looking for a job at any level at the not-for-profit space, whether it's an entry-level job, staff-level job, or a CEO or chief operating officer job, the first order of business is to take a look at the board of directors and send that listing of board of directors to your network and ask a simple question, who do you know? Because if you have any sort of contacts, that will ensure that at least you get a look, that your resume will be removed from the pile of 50 or 100 or 200 resumes that may flurry the inbox of a hiring manager. Understand your competition and make sure you have the ability to articulate how you added value. You find that there's a fine line between talking about one's skill set and bragging, and you don't want to encroach upon into the area of being bragging or braggadocious, but it's extremely important to talk about adding value. The resume game. The resume game is like the lotto. As they say colloquially, you have to be in it to win it. And when you see a job, it's important that you apply for that job. You should bear in mind that when you see a job, depending on the jurisdiction, places like New York, Chicago, Los Angeles, by the time you see a job as few as 10 and as many as 50 people have seen that job already. So if you multiply that every day, your competition is steep. However, you still must play this resume game, and when you see a job, you should apply in a timely manner. Deciphering the meaning of the job posting. That means you should look at the job posting and make a decision as to whether they're interested in an entry-level person or whether they're interested in someone with experience, because it's important. It's having a mentor and a sponsor, which are easier said than done. The mentor is the person with whom you've had a significant professional relationship and interaction, and someone who has an interest in seeing the ascendancy of your career. The sponsor is someone who has the authority and the gravitas, or perceived authority and gravitas, such that when they say, hire Mary Smith, that those in the positions of hiring will take that recommendation with a high degree of credibility. Volunteering and consulting are ways that have become gateways into employment over the past 5 years, so those should be options that should be considered. Webinar takeaways. Should be able to recognize the triggers of transition. That includes changes in management. That includes that if you're working for someone who has less credentials than you, so if you're a graduate of Holy Cross College, you have an MBA from University of Chicago, and your supervisor is a high school graduate. That usually creates an interpersonal dynamic of stress and challenges such that it may trigger challenges in the workplace. You should have learned how to protect your reputation. Maintaining a diary is critical. You should understand that when you are presented with a severance package, that it is the beginning and not the end of a negotiation. To think about re-entering the workplace after you leave. Continuing education is important. Assessing the culture is important. And something that I neglected to say about cultures. There are a few cultural dynamics in the workplace, and they're as follows. Collegial, competitive, aggressive, factions, and toxic. Collegial is where, as indicated, people are working together towards a common goal. Competitive are where there is healthy competition. Sometimes there are environments where they're competitive, but it's more cutthroat. Factions is where you have a particular group within the organization that actually controls the operations, practices, and policies. A toxic environment is one where the hallmarks of a toxic environment are high attrition rate, lack of transparency, inconsistent policies and practices and the implementation thereof, and unfettered authority in certain individuals. Final takeaway is understanding the at-will doctrine. Now, going back to that initial fact pattern, where you have this employee who is objectively the top candidate, however, the candidate, you just don't like that person. How many of you would hire someone, despite the fact that they are objectively the best person and the strongest candidate, how many of you would hire that person if you didn't like them? At the end of the webinar, please send me an email that says either hire or not hire. I received some pre-webinar questions last week, and so before the process, so I just want to address some of those as well. The first is, do you have any advice for a consulting practice following organization affiliation? I think it's important to note that it will take anywhere from 2 to 3 years to develop a consulting practice. That what's important is that you identify the possible clients and potential first clients, and quite frankly, first clients may even include the former employer. You should also consider working subcontractor opportunities if you have relationships with existing consultants. That's a good way of developing relationships and creating relationships. You may have to go on a bit of what I call a listening tour. That's where you're meeting with various parties, getting a sense as to what's needed in the workplace, where there are challenges and issues, and how you can develop your strengths and weaknesses and niches. The next question is, are there specific do's and don'ts for people over 55 adversely impacted looking for employment after layoff or merger? Yes, there are many do's and don'ts, but I will say this in the interest of brevity and time. So number one, if you have an email address, if you have an AOL account, you should not use it. You should get a Gmail account, because what happens in the workplace, and while there are laws that prohibit discrimination in certain kinds of arbitrary selections, that when employers see, especially those doing the selections, when they see an email address that says AOL, there's a presumption that the person is of a certain age. So that's something that you may want to avoid. Something else, you really should consider the possibility of consulting or temping as a way of identifying new opportunities. The third question, do I ever have to retire? Realistically, what do statistics show? If retirement means that you no longer will have another employee-employer relationship, then the technical answer is no, you don't have to retire. The practical answer is, however, that many employers, including government, have limited budgets, and retirement after a certain number of years is in the best interest of the employer. With that being said, that people are living longer in a society, they're viable, and most of us will have skill sets beyond the retirement age. So my suggestion is that if you are interested in working after retirement, as many people do, then you need to cultivate the kinds of relationships and be prepared to transition into new and subsequent industries. How can an older worker effectively market their experience? I would say that instead of, we shouldn't think of ourselves as older workers or younger workers. We should think of ourselves as degrees of experience. And those who are older have greater experience, at least presumably. So in marketing oneself, one has to think about the 15 years of experience as a marketer, the 20 years of experience as an educator, the 35 years as a judge or a litigator. How do I choose a good next opportunity after a planned departure? Well, identifying the next opportunity is really a function of the following. Number one, an assessment of your skill set. Two, an assessment of your network. Three, introspection. That those things have to be done. How do you know if your response to changes in the workplace should be forming your own company and being your own boss? That's really a similar question to the first question, and so I'll just defer to my previous response. Oh, I'm sorry, I neglected to read number 4. For millennials, 2 years is too long. How do you protect your reputation as you negotiate and navigate a protean career? A protean career is one where there's a lot of movement, and as I said earlier, 25, 30 years ago, that would have been a red flag, but now it's considered the norm. So with regard to protecting your reputation, I go back to, once again, creating a diary, developing a track record of adding value, cultivating relationships with colleagues, and those are the kinds of experiences that will bode well in the future. How important is LinkedIn for career transitions in today's job market? I'll say it's very important. There's a presumption that you'll be on LinkedIn, not necessarily actively engaged, but that at a minimum your current employer or your current achievements are listed on LinkedIn. How do I address the prospective employers? How to address with prospective employers being unemployed after resigning on one's own from a previously toxic employment workplace? I will say this, that if you've been in a toxic work environment, it's important that you not besmirch the employer. It's important that you not malign the environment, even if it was toxic. So therefore, you must come up with the kind of language that suggests, A, that your departure was planned, B, that the departure as part of your professional goals and objectives was planned. For example, there are some people who say they want to work 3 years at one firm and then they want to work another 3 years at another firm and another 5 years. So it's in order to effectively transition from what was a toxic environment, it's important that you, A, not malign the firm, B, not disparage the organization, but find some facile and plausible way to convey that you have transitioned on your own. I'm returning to the workplace after 5-year absence due to medical condition. What things should I be most aware of? Well, after returning from medical leave, you should be aware of any changes in the industry, which is why continuing education is important. You should also, if you're not involved, should be involved in professional associations and be cognizant of any cultural changes in the workplace. like a phenomenon over the past 15 to 20 years is the advent of business casual. I will say parenthetically that be very careful of the business casual environment. Note that the dress may be casual, but the business environment is very rarely casual. What is the average number of employers a woman will work for in her lifetime? Does that number differ for men? Unfortunately, there are no statistics specific to gender. However, conservatively, in this current workplace, conservatively, anyone who's graduated over the past 15 years will have as few as 6 and as many as 14 employers, and that applies for both men and women. Any questions?
We've had a couple come in during the course of the webinar.
Okay.
The first one is, if one's job description or conditions have changed substantially, or if a new position is offered that is substantially different from one's existing job, even if salary is not affected, and one chooses not to accept this position, can the employee refuse the changed position in such a way to be sure any separation from the organization is deemed a layoff? In other words, allowing the employee to qualify for unemployment.
Well, let me answer it this way. The employee can refuse to accept it. However, the employee, especially if the employee is an employee at will, that can be terminated based on the fact that they didn't want to accept the job. With regard to the distinction between a layoff and a resignation, once again, that really goes to the negotiation. I will say, though, that with regard to the job descriptions, and I neglected to make this point, that all employees should keep their initial job description as well as annotating or making notes with regard to any subsequent substantive changes in their job description, because it may be important, particularly during a severance negotiation. So in short, yes, the employee has the right to say, wait a minute, if you're going to add these 15 new job functions, I don't accept that, but a possible and likely consequence is that the employer will terminate the employee.
Okay, got time. We'll try to squeeze in a couple more questions that have come in. Here's one. How does one negotiate a severance clause when negotiating a new contract, and should we?
How does one negotiate a severance clause when negotiating? The way the question is posed is suggest that there was already a contract in place, and this person at the end of the contractual period wants to negotiate a new contract and including a severance clause. Well, that would be done. That would be articulated as part of the terms and conditions of the contract. Now, I'm offering this answer based on an interpretation that there's an existing contract. If there's an existing,
actually, it looks like, sorry to interrupt. It looks like that's actually for a new. She's talking about for a new job, not renegotiating a contract, a new job.
Okay. Well, for a new job, as I pointed out, there are two kinds of relationships. If the employee-employer relationship is one where it's contractual, so you're coming in usually at a higher level and there's a contract in place, then what the employee or what the new employee can say is that in the event of termination that I expect X number of weeks of severance package. That must be negotiated upfront with great zeal and vigor and advocacy, and that's one way to do it, and it can be done. Now, if you're an employee at will, then that usually is not permissible. I mean, as an employee at will, you have the right and power to negotiate, and you should, with regard to salary, with regard to certain terms and conditions, whether there's a vehicle, whether there's not a vehicle, whether you can work remotely, those kinds of things. But as far as something like severance package is usually limited to contractual negotiations, and in this case, you'd be able to make that request. The issue is whether the employer is amenable to that.
Okay, I think we're going to squeeze in, we've got two more questions. I think I can combine them. They're similar. One is, I left one position and took a job in an unrelated field while looking for a new position. Should I include that on my resume to avoid job gap, or will that raise red flags? And then the other one is, I left a very public position with a great deal of local public speaking, et cetera, and subsequently took 3+ months off. I initially declined offers to speak locally. Is there a good explanation for this time off? So what's the best way to address job gaps or something that you took in between to tide you over?
Okay, well, the best way is to be truthful, and I will recognize that being truthful may not necessarily inure the kind of results that folks may want depending on the situation, but the first response is to be truthful. The other thing is an employer would like reasonable explanations for job gaps. So maybe there was a health issue, maybe you had to take off time to help tend to an elderly parent, maybe one was contemplating transitioning into other industries. And so job gaps, which are a red flag, but they're usually addressed by plausible and viable explanations that include illness, unforeseen circumstances with respect to the care of family, and a whole host of other issues.
All right, so we will wrap it up. Many thanks to Ricardo for sharing his time and knowledge with us today. If you're interested in working with Ricardo, his contact information is up on the screen now. If you miss it, just email me here in the alumni office. And thank you for joining us. A recording of this presentation will be available on the Holy Cross alumni website next week, and I'll send out an email to everyone when it's posted. You will also this afternoon receive a short email survey about the webinar, and I encourage you to share your feedback with us. If you have any follow-up questions, please reach out to me here. Our next webinar will take place in November. Look for more information at the end of this month, and registration will open on November 1st. I also want to let you know that we have our kickoff online networking event next Wednesday, October 19th. Encourage all of you to join in there. There will be a link to it in the email that you receive this afternoon. Again, thanks for joining us. Thanks for your patience, and have a great afternoon.